Good evening. Thank you for joining. I'm thrilled to be able to provide a webinar for you. As many of you know, I'm Daniel Bornstein. I am a practicing attorney with Bornstein Law. We have offices in San Francisco and in Oakland. And as some of you also know, I'm a broker, a real estate investor, also serve as an expert witness, and also have a brokerage called Bay Property Group. We manage properties throughout the Bay Area, have approximately 800 units under management. And today I am thrilled to be able to invite you to do a bit of learning with me. I want to emphasize this. I can't put on a webinar without a team, and there are team members who assist and facilitate. And with me tonight are Ethan and Bharat, who are here to ensure that this program occurs successfully. And there's a lot of work putting this on. And I want to congratulate you for making the decision to participate, because when you commit to educating yourself, you become better in real estate. And I will tell you, the most successful investors, the most successful real estate holders are those who have a working knowledge of the law and continue to educate themselves about the nuances and difficulties inherent in being a housing provider in the Bay Area and in California in general. I can only tell you, it is getting extremely tricky. It is getting more complex. Post-COVID, we're still dealing with the repercussions of the COVID pandemic, and we're still digesting state rent control, state just cause eviction rules, and a cascading of new laws that keep hitting us as a community. And it's my job to keep you informed of what I think are key new laws that you need to be familiar with so you don't get yourself in trouble. First part of this webinar, we'll be going over new laws. The second part will be discussing how I look at a property as a property manager, how I look at a real estate investment, and how I try to position excellent property management for success for your real estate investments. So with that, let's jump in and fasten your seatbelts. And I assure you, you may have questions. Email me tomorrow or tonight with your questions, and I will be glad to answer them if I can. If they require more information, I will, of course, provide it to you. Also, at the conclusion of this webinar, either tomorrow or shortly thereafter, we'll be sending you the PowerPoint slide presentation so that you have it, and you are welcome to disseminate it to others who may find this information important. We'll be also uploading the webinar so that people can access it on YouTube and other sites. So with that stated, let's jump in. Let's begin by talking about some new core laws that affect all Californians, and one in particular is the most impressive, unfortunate change in California, which is the new statewide security deposit law. Many of you know the most likely dispute you will ever have with a tenant is on the security deposit accounting, and a dispute as to whether you took an unreasonable deduction or a fair deduction. And if you go to small claims court and observe the day-to-day small claims court filings or the actual hearings, you're generally going to see a security deposit dispute arise in that courtroom. Remember, in small claims court, you don't have an attorney. The unfortunate thing we are faced with as of July 1st, 2024, which is approximately 5 weeks ago, is the introduction of the new state security deposit law. Let's make sure you understand it so that you are not falling prey to ignorance. And there are so many of my clients, they're wonderful people, they have excellent character, but they simply are ignorant of the law, and they are a bull in a china shop, violating all sorts of landlord-tenant laws without understanding why, and then I have to engage in corrective action. My goal is proactive action, and that's why you should, again, congratulate yourself for being here. Let's look at this. Effective July 1st, 2024, for larger property managers, property owners, you're only entitled to demand 1 month of rent for a security deposit. This has an exemption for smaller property owners, and you have to ask yourself, does the property owner own just 2 properties? Are there 4 or less rental units under ownership? If you are a mom and pop owner, you may still be entitled to collect up to 2 months of security deposit. The public policy behind it is that California is expensive, rents are expensive. It's very cumbersome and challenging for some tenants to be able to afford a rental unit when you're being asked to come up with 2 months of a security deposit plus that first month of rent. So of course, in their wisdom, Sacramento legislators put into effect this law. And what it means by, in my mind, is many of you, especially larger property owners, are going to be left holding a debt at the conclusion of a tenancy, because the 1 month of rent will not be sufficient to cover unpaid rent, unpaid utility bills, and damage to your unit. That's the nature of bad public policy. Most importantly, you need to be compliant with the law. So let's look at this. Bornstein Law and Bay Property Group put together this flow chart for you to try to discern exactly under what circumstances you fall within that requirement of a 1 month security deposit demand or a 2 month security deposit demand. We always go from top to bottom in our flow charts, and this will help you discern whether you are a 1 month or a 2 month security deposit seeker. The first question: is the landlord a natural person or an LLC in which all members are natural persons? If the answer is no, your security deposit can be no more than 1 month's rent. If the answer is yes, then we ask the following: does the landlord own more than 2 residential properties that collectively include more than 4 dwelling units offered for rent? If the answer is yes, the individual owns a 10-unit property. The individual owns a 6-plex, security deposit of only 1 month rent for new tenancies that have commenced as of July 1st, 2024. If the answer is no, this is a single owner who owns the property in their own name and they own a single duplex. Then you ask, is the tenant actively serving in the military? If the answer is yes, security deposit of 1 month's rent. If the answer is no, the tenant who lives in the duplex that you own is not in the military and you only own 1 duplex in your own name, then you can ask for a security deposit of up to 2 months rent. Got it? We go through this slide flow chart and we come to the answer. The reason why I create a flow chart is because if you actually go to the statute, your head will be spinning trying to figure it out. This statute, as identified in this flow chart, gives you a general understanding of how it works. Remember, if you own a single family home or a condominium in your own name, up to 2 months rent. If you own a 5-unit property, a 6-unit property, or you own 3 triplexes, 1 month rent for all future tenancies. Remember, if you started a tenancy in January of 2024 before July 1st and you ask for 2 months rent, you are okay because the law became effective as of July 1st. You do not have to return a portion of the security deposit. It's simply for new tenancies, you're going to have to follow these rules. Thank your legislatures. This is ultimately going to result, in my mind, with owners having to chase tenants at the end of a tenancy in small claims court because the amount of the security deposit of 1 month's rent is not going to cover the damage that typically arises above reasonable wear and tear when a tenant transitions from the property. So in the end, what we think of as good policy turns out to be aggravating because it enlarges the risk of additional litigation between landlords and tenants. It may result in an easier entry into the unit, but on the exit, we have more stress, we have more aggravation, we have more litigation, and all I can tell you is this: don't get angry with me. I'm simply the messenger giving you the knowledge so you can move effectively in this space and not make mistakes. If you're upset with it, you have a number of options. One, you can sell your property and not be in California. Two, you can write a letter to your legislator. Three, join a trade industry group and make sure you lobby effectively so that in the future we're not subject to this. Unfortunately, California continues to be a state where the vice of additional litigation and additional statutes limiting property owners' rights continue to become more and more prevalent as time evolves. For example, SB 712. We love electric vehicles. We love the battery industry. It's helpful to our environment. But sometimes the thought behind a law is not well considered. I want you to know that this is shocking, but you need to be familiar with it. SB 712 allows a tenant to store a micro-mobility device in their rental unit so long as the batteries meet certain safety standards. The question is, does the landlord provide the tenant secure long-term storage outside the unit? If so, the landlord can mandate that the device be stored in the storage space as long as it meets statutory requirements. This means that if your tenant has an electric bicycle and you don't have a storage unit for that electric bicycle, that tenant can bring that bicycle up into the tenant's unit, store the bicycle in the unit, and also charge the vehicle in the unit. I believe it's imprudent. Having vehicles, whether they're scooters, whether they're bicycles running up and down a common area hallway, it's a safety hazard. Having batteries being charged inside a multi-unit residential apartment complex, not prudent, but this is the law as of this year. Now, I told you that the rule is as long as the tenant has a battery that's certified. The information of what certification or a qualified safe battery is right to my side on this screen, and you have it in the PowerPoint slide presentation. I also told you that the one exception to preventing a tenant from bringing and storing their electric skateboard, their scooter, their bicycle inside your unit is if you have long-term storage outside of your unit. And it's not just a shed. What you actually have to have is that access is limited to residents of the same housing complex. It is located on the premises. It is reasonably protected against precipitation, and it has a minimum one standard electrical connection for each personal micro mobility device that will be stored and recharged in that location. Now, how many of you have that? You may have a parking garage, but that's not enough. You have to have a storage area that's secure, risk-free from precipitation, not available to others, and then you have to allow electrical usage for people charging their vehicle. Question: who's going to pay for that electrical usage in the common area storage unit? The owner. So this law not only requires you to permit tenants to use their room or their rental unit for storage of their micro mobility devices. But if you do have a separate space designated for the storage of these vehicles, you're going to have to provide electricity. So it's a losing proposition for you, one way or the other. Of course, the public policy behind it is to help ensure that our society embraces electric vehicles, but you as a property owner provider are the ones that are paying for this privilege. You're either paying for it because the damage that arises inside your building by having a bike coming in and out of your common areas is going to harm your building, or you're paying for electrical in that storage location, or you're facing an increased risk of fire with a bunch of bicycles being charged on your electrical system. Pulling electricity from your building may be out of proportion to what your load can provide. And if you have an older building that already is already experiencing difficulty with electrical loads, you've got yourself a problem. I didn't make the law. Again, I'm the messenger. Be aware, if a tenant says, I'm moving my bike up into my room, and you say, I'm sorry, we don't permit bike storage in your room. If it's an electric bike and you don't have a storage facility, you are out of luck. Today you learn the law. Call me if you have questions about it, but now you understand that tenants will have the right to store their vehicle inside their unit if you don't have a separate, secure storage facility that is located on the property, protected against precipitation, and has electrical outlets available for people to charge their vehicles. All right. Another rule, and this is tricky. I want you to know that for the last 30 years, I've been teaching people about what to do and what not to do. And maybe about 20 years ago, I started to teach people that if someone says they have an emotional support animal, I always tell them to say, we welcome all applicants. You don't say, I'm sorry, this is a no pets building, because a service or an emotional support animal is not a pet. Well, now I'm teaching people about this. If someone says, do you accept Section 8 or do you accept a voucher? You don't say, I'm sorry, we don't accept Section 8. That's going to create a risk of discrimination. You always say, we welcome all applicants. There is a gentle attorney, and I don't think he's that gentle, but there is an attorney in the East Bay who is suing people who advertise on Craigslist, advertise with statements saying no Section 8. That's a violation in San Francisco, and it creates liability for you. If someone calls you up and say, do you accept a third-party voucher? You say, we welcome all applicants. Please complete an application and we will evaluate you fairly like we evaluate everybody. Got it? Someone asks you a question, we invite all applicants to apply. The filing of lawsuits for discrimination, whether it's a violation of fair housing because of an emotional support animal, a violation of an extended family because you said that the building is too small, the unit is too small for a five-person family, whether you say, I'm sorry, we don't accept Section 8, you've got yourself liability. When in doubt, always, we welcome all applicants. Please apply. This new law, SB 267, you need to recognize that if someone has a voucher, and let me give you the example, you advertise your rental property for $1,000 a month. It's a studio. The tenant informs you that they have a voucher from the Berkeley Housing Authority, or the Oakland Housing Authority, or the San Francisco Housing Authority, equivalent to $800. How much does the tenant have to come up with each month to pay that rent? $200. You as an owner are not allowed to use the credit report to screen a prospective Section 8 tenant, but instead, your inquiry must be, does the rental applicant have alternative evidence of financial stability and the ability to pay that portion of the rent that they're going to be responsible for paying? So we're not looking at whether the tenant can pay the $1,000 a month of rent. We're looking to see if the tenant can provide proof through employment, through savings, through other legal means of being able to competently and consistently pay how much a month each month? $200. Many of you are unaware of this. It's tricky. Many of you have math for your people who qualify for rental units 3 times your income. Well, for a Section 8 tenant who has a voucher, we're not looking at the credit report. We're looking at whether the tenant or prospective tenant has evidence of the financial stability and ability to pay that portion that they would be responsible, different than the subsidy that is coming with that occupant. We never summarily reject a tenant because they have a voucher. We welcome all applicants, and I want you to know, we do not look at the credit report. We look at whether they have credible evidence to substantiate that they can pay that portion. And if they can pay that portion, you can't reject them on the basis that they don't meet threshold credit requirements. However, I want you to remember this. While a tenant may be able to demonstrate that they can cover the $200 a month payment because they have a job and they make $800 a month or $1,000 a month, they may still fail in your application process because poor landlord references, no professional references, no personal references, or they haven't completed your application completely. What I'm trying to say to you is, even though you have to consider the applicant, that doesn't mean they get the right to the place if they don't demonstrate other aspects of the application process that's appropriate in evaluating whether this person meets your threshold requirements for offering the unit. The easy situation is oftentimes poor landlord references. And when I say poor landlord references, it may be that the individual gives you landlord references and you can't get a hold of the landlord. If you can't get a hold of the landlord, the former landlord, they haven't satisfied your application process. It's up to them, if they're giving you a reference, to let that reference know that they may be contacted and you very much want to have a communication. So you may be entitled to reject someone because you can't substantiate the information that's on their application. So though this is a problem for many people, though this is a new rule, you have to realize you're not 100% a victim here. You're still able to evaluate other aspects of their application to determine whether they meet the parameters necessary for you to offer them the unit. Not allowed to discriminate, not allowed to use a credit report, but you are allowed to make those assessments of whether they completed the application, whether you can verify their employment, whether you can verify professional, personal, and landlord references. And if someone's a stronger candidate, you're entitled to choose them. All right? And you never, ever offer a unit to a tenant if you haven't had the opportunity to talk with references. The worst thing that happens is you get finessed by a beautiful person who makes a great first impression, and then 2 months later you realize that they're terrible of character. And all they were good at is that first impression. I am acclimated to that because as an attorney handling disputes in landlord-tenant matters, I often hear, they were so lovely when I met them, and they offered me cash immediately, and I was having difficulty renting the place, so I was so excited that I was finally able, after 3 months, to get the rent I was looking for, and they seemed so wonderful. Did you call their landlord references? I called their landlord references, but they never responded. But I just felt like this was a great opportunity for me to finally get someone in the unit. That is a mistake. We'd rather have a vacant unit than a poorly chosen tenant because the aggravation of trying to transition a tenant out of a property is so great that you wish you never rented to that person previously. Be advised, discrimination lawsuits are occurring all the time. There's attorneys who specialize in just suing owners simply because they made a mistake in saying we don't accept Section 8. All right? So when someone asks you a question, do you accept a voucher? You say, we welcome all applicants. Please, I'll send you the application. They say, are you sure you're going to accept Section 8? You say, you know what? I welcome all applicants. We're inviting you to apply. Please apply. Then you do your due diligence. And for this slide, remember, you're not entitled to use a credit report where we have someone who has a voucher. You're going to look at what their portion will be in the contribution and see if they have verifiable information that can substantiate that they have the ability to pay. Balconies, right? Many of you who are Berkeley property owners remember the catastrophe and the terrible situation of this group of Irish students who were here in the summer, maybe 10 years, 15 years ago, and the balcony collapsed and people were killed, and it was a terrible, terrible tragedy. In light of that, this law came into effect, and now we have a situation where if you own a building, 3 or more units, you're going to have the balconies inspected, and you've got to get ready, and it can't be your handyman who's not a licensed handyman. There's requirements, and I can only say this, the law is tricky. It defines balconies in certain different ways, depending upon if it's a wood balcony or a steel balcony. There are different rules. Most importantly, you know today that you've got to have balconies inspected if you have 3 or more units. And it's costly. I went out, I also own some real estate. I went out and got a bid for a inspector to inspect the balconies, $250 a balcony. If you got 25 balconies on a building, that can become an expensive proposition, and this issue is going to continue to bleed you. And unfortunately, it doesn't include a provision that the tenants will contribute half of the inspection costs. The tenants contribute how much of the inspection cost? 0, right? Again, the financial obligation is on the housing provider. Some of you will believe that's inherently unfair. Some of you will say, well, the power dynamics between a housing provider and a tenant are such, it's the housing provider's property. They're offering the unit. They need to make it safe. They need to make it ensure that it's safe. And other people will say, well, it's a community issue of ensuring safety in places people reside. For me, again, my job is to educate. I tell you what the public policy is. It's certainly important that we have safe balconies. The question is whether or not everybody should contribute or whether only the property owner should. Be advised, it's not a handyman. You're going to have a licensed contractor, an architect, an engineer, or a building contractor who has a special license to engage in this type of inspections. Berkeley. So a little bit of knowledge. I've been doing this for 30 years. And when I first started, there were 3 ordinances. There was Berkeley, there was Oakland, there was San Francisco. Since that time, there are now about 14 or 15 local ordinances throughout the Bay Area. And if you're following the news, every couple months another city council starts to talk about a local ordinance. It used to be that Berkeley was the most pernicious of the ordinances, then San Francisco became really restrictive, and now Oakland is particularly pernicious. And then on top of that, if you don't have a local ordinance, you're going to segue into what? State just cause eviction rules and state rent regulation, which means that in order for you to be participating in this industry, you have to at least be able to know whether your property is subject to a local ordinance, whether your property is subject to a state ordinance, and the nuances of that. If you don't know that, by all means, call me up, email me, and I'm happily able to step you through this. In Berkeley, which landlord-tenant rules is a blood sport, we have the Berkeley Property Owners Association, a lovely organization that is working so hard to try to protect property owners from unfairness. And what we have right now is competing statutes or regulations that are going to be voted upon. We have the city council measure, which we know is going to be favorable to who? Tenants. And we have a Rent Relief and Homeowners Protection Act, which is more conducive to the goals of property providers, which expands exemption to all owner-occupied duplexes instead of just golden duplexes, creates a pool of funds for rent relief, allows owners and residents to agree upon rent increases when there are improvements to the unit. Seems reasonable to me. But we have a countervailing ordinance that will cap increases at 5%, remove a just cause eviction under the rent ordinance, and authorizes unionization of tenant groups within a building. We have tenant unions in San Francisco. Berkeley is trying to legislate tenant unions within buildings as well. I can only tell you that I've spent enormous amount of time in San Francisco in these Zoom meetings with a tenant group to talk about the existence of the building, and it is a exhausting process. It is expensive for an owner to hire me to be participating in it, and so any of these sort of unionization efforts where you have a collective group arguing for certain repairs or certain issues, it may be a fair request, but it's an expensive process, and I would strongly suggest that we try desperately to vote in favor of the Rent Relief and Homeowners Act and not support the city council measure. I can only say to you this: the Bay Area is very progressive. The Berkeley community is even more progressive than others, and we are now faced with that continued tension between landlord and tenants, which polarizes the community and unfortunately creates more recipe for conflict as opposed to a approach that is more collaborative in nature. And here's what we have in Berkeley. Now, what are the overall challenges that I'm seeing throughout the Bay Area? One of them is softening rents, and we have survived COVID. There's been employee difficulty when you read in the newspaper that an employer is leaving town, when you see in the newspaper Chevron is leaving and moving to Texas. You're also recognizing that that has an impact on valuation of rents because it's largely dependent upon demand. And what we have here is softening rents, increasing operating costs, such as the increase in cost of balcony inspections, continued regulations, lawsuits, and finding and retaining quality tenants. And then another one, insurance. And I didn't put that on the bullet because I forgot. But insurance is becoming a reoccurring theme in my discussions with lots of people. The increase in insurance, or a client calling me up and saying, I lost my State Farm insurance. This is a crisis. And the only thing I can tell you is we all share in this problem. I don't have a solution. I can only tell you that when you look and evaluate a property as a real estate investment opportunity, you ought to consider that the numbers that they're providing you need to be multiplied, because the cost of owning real estate with all the additional expenses, with inflationary trends, with increased utility costs, with increased insurance, you've got to be very, very smart about whether you want to get involved or not. And I have seen some of my clients selling properties in the Bay Area and moving their investments into other parts of the country, because they're fed up with the overregulation and the increased costs. And that's a choice you can make. Some people are still in the Bay Area, and generally, Bay Area real estate increases in value faster than other investments, but it comes with heartache, especially if you have a tenant problem. For those of you who are, in some respects, handcuffed to a property, because if you sell the property, you have a large taxable event that you don't want to engage in, and a 1031 exchange is going to result in you having to pay additional cost with additional property taxes, so you're stuck on a property, and then you have difficulty in managing the property because you're now at a point in your life where you'd like more freedom. Well, one of the things is considering property management. Excellent property management requires excellent communication with tenants, both difficult tenants and wonderful tenants. Bookkeeping. Every month you're receiving funds and you have to properly account for it and properly pay invoices, mortgage, insurance, taxes, and also knowledge of the law. And what I have found in my work as an attorney is that there are some property management companies who are excellent at communication, but when you talk to them about the law, it becomes really tricky for them. Or they're very charismatic, but the bookkeeping is no good. So when you're choosing a property management company, you want to make sure that those three pillars are available to you. And this also means the same for you as a property owner. If you're self-managing and you're ignoring tenants who are requesting repairs, and it takes you 3 weeks to get back to a tenant who has a burner on their stove that's not working, you failed. If you can't keep track of your rents because you don't have any sort of system in place to keep track of your rents, you got yourself a problem. And I can only tell you how many people call me up and I say, well, send me your rent ledger. And they say, what's a rent ledger? And I'm like, well, how do you keep track of what you receive? Well, I got a piece of paper here, a piece of paper there. Say no Excel spreadsheet, no other way of managing it. They say no. I say, okay, take pictures of your documents and send it to me. And then we have to do a forensic check of what the rents were. And the reason being is that there are some people in this real estate industry, they didn't self-select into being a real estate investor. They inherited property. Or somehow they came to be involved in rental property, but they actually never developed the infrastructure. If you don't have the infrastructure, you don't have the patience, you ought to consider property management. When we do property management at Bay Property Group, these are the things we're looking at. Excellent communication, meticulous bookkeeping, and then because I'm the broker, I have that ability to understand the law, which a lot of property management companies don't have. Renting. You got a vacancy. Many of you are motivated by, I want to get the highest rent possible, right? Because I know in Berkeley, once a tenant comes in there, every year they're in there, the rent is less than what I could have gotten if it was vacant because market rates tend to increase and it becomes more and more expensive the longer someone's in. So when I have a vacancy, I'm trying to get the highest rent. Well, I want to let you know this. The highest rent, if marketed at the highest rent, will likely result in less people applying. If you have less people applying, what are you going to have? A smaller pool of applicants, and you may not get the best applicants. You may think, well, if I keep it high, then I'll have excellent tenants who are earning a lot of income. Well, that could be the assumption, or they could be people who are happy to overpay as long as they actually get a place because they have a history of bad relationships in the past. What we want to do is try to get the sweet spot of the relationship. We want to, of course, get as high a rent as possible, but we also want to locate that group of tenants and the applicants where you're getting a nice diversity of applicants so you can find that strongest applicant, right? You want someone who, for your Class B 2 apartment unit in Oakland, has a job with PG&E, who has a government job, who has a 2-income family, who has stability in their income. They're not someone who has intermittently had jobs and not had jobs. Making a decision of how you offer a place for rent is tricky. The website I go to often is Socket Site. Socket Site is a website that provides the ability to actually keep informed of prevailing real estate trends. Socket Site. And they often give you information about rents in different regions, whether they're going up or not. And so I would invite you to Google the word Socket Site, and it's something that I keep informed of. One of the things is, look, in different locations, you have different price points. In Adams Point in Oakland, we're going to have a different price point than if we're going to have a price point in Fruitvale or off of International Boulevard. There are micro places, and your job as an owner is to get a good sense of what your pricing is for your particular space. We don't want to make that offer rent too high so it sits on the market. We want the sweet spot to attract as many quality tenants as possible. It is not a math problem. It's an art issue. You have to determine what is that price point that will attract enough people that's high enough to justify you renting. And that something is not a math problem. It's a little bit of a science. It's a little bit of an art. And if you're struggling with that, we are happy to talk with you about this. Another thing, this statement, the greatest predictor of dysfunction in a rental unit is prior dysfunction and indicators of failed rental relationships in the past. So, if someone's engaged in criminal conduct in their past, that is the best predictor of whether they're going to engage in criminal behavior in the future. If someone has a poor tenant history in the past, that is a likely predictor of a future poor relationship. That's why I emphasize when you actually evaluate a prospective applicant, you really want to drill down on their history. And if you get a communication from an owner who tells you that they wouldn't rent to the person again, and they tell you they had a poor payment history, that may give you enough information to choose a stronger candidate. If they say this person was disrespectful and I asked them to stop smoking in the unit and they continue to smoke in the unit and it caused other people to be upset, that's a poor record, and that's a predictor of what? That the person is likely to engage in that same disrespectful conduct within your unit. So dysfunction that occurred in the past is the best predictor of it occurring in the future. And I'm going to take questions at the end. So your job is to discern this. And the best way to discern it is diligence in the evaluation process. I may not want a tenant willing to pay the highest rent if the tenant's landlord references are ambivalent at best about that person. But if I have someone who says, I can't afford $2,200 a month, I can do $2,000 a month, and they have a sterling record of outstanding, excellent landlord references, then you've got a big decision to make. And that's the evaluation process that we go through because we don't want dysfunction inside your unit. The reason being is if you have dysfunction inside your unit, it doesn't just affect that unit. If you've got a multi-unit property and you have someone who's disrespectful, bringing in people at all hours of the night to party, you know what? You're going to be upset with that person, but you know what's going to happen? All the tenants in your building are starting to complain to you, and then they have a rent strike until you deal with this person, and you've created an environment where dysfunction is deteriorating the quality of the community. And so even though I'm a landlord attorney or a property owner attorney, what I really do is help sort out and ensure the stability of communities so that they can function effectively. And sometimes that requires to transition a tenant out. But the most important thing for you as a real estate investor is don't bring the dysfunction in the first place. How do you do it? Diligence at the selection process. We try to look at the available information about the person. You can do database searches. You can hire a private investigator. You can do many different things to discern about the person. Social media provides an enormous amount of information, but you really want to triage the information. Credit report for individuals who are not Section 8 based, right? That's great information. Professional references, personal references, how they interact with you. Those are the things we do, as well as looking at the history of their landlord relationship. And let me give you an example. If you got a 45-year-old person and they give you rental history from the 80s, and they give you rental history from, or not the 80s, rental history from the 90s, and they give you rental history from 2015, but there's like 7 years where there's no rental history in their information, what does that tell you? It tells you they probably had a bad relationship with someone and they don't want to give you that information. So I want to see continuity in that rental application, showing that they've been one person to the next person to the next person. And if there's a hole, I want to know why there's a hole. Oh, I bought a property, it was foreclosed upon. Okay, understood there was an economic crisis. But if there's, oh, I had a bad relationship with the landlord, then I want to know about that. Or I want to find a stronger candidate that has a consistent history throughout. We're trying to always get that information so we don't put someone in your unit who turns out to be a problem. Very important statistic. 70% of turnovers are typically due to the neglect by an owner or a property manager, or the apathy of a property manager. 30% of it is changed circumstances of a tenant. Generally speaking, every 7 years you get turnover in a unit, generally speaking. In a rent-controlled jurisdiction such as Berkeley or Oakland or San Francisco, it will be longer, because the longer someone stays in the unit, the cheaper it is for them, which means the selection process is even more important. So if you're going to have below market rent, at least you have a wonderful tenant. And remember, as I talk, I want you to remember, there are wonderful landlords and there are less than wonderful landlords. There are wonderful tenants and there are less than wonderful tenants. I want you to have a great relationship with a tenant who pays consistently, who's helping to ensure the quality of your building. And the only thing is, the choice of that person is what you have to be familiar with. Our goal is to retain ideal tenants, and here's the issue. One differentiator for Bay Property Group. If we select a tenant and that tenant fails to pay the rent in the future, we will offer what we call a no legal fee guarantee, which is we will transition the tenant out without legal fee. And that's a differentiator. The hope is we never have to use it, but sometimes circumstances change. You have wonderful tenants who go through a loss of a job and they're not paying the rent, and you have to ask them to leave. What we will do is, if we put a tenant in a unit and qualify them, if ultimately in 5 years they did not pay the rent because of circumstances, we will handle the transition without actually the legal fees that are generally devastating to a person when dealing with Alameda County Superior Court or any other place. If anybody's gone through an eviction and paid an attorney to deal with an eviction, it can ruin your year in terms of revenue, because it can become very, very expensive. Remember, when you place a tenant in a unit, at the commencement of the tenancy, you've got to be diligent about the move-in process. The move-in process requires documentation of the condition of the unit. And you may be so excited about having a tenant sign your great lease agreement that you fudge the move-in process. The move-in process is where you document with video, with photograph, and with a move-in form the conditions of the property, not because you're doing this just to make me happy. You're doing it because at the end of the relationship, when you're doing the move out, you need substantial documentation to prove that the damage that arose at the property is above reasonable wear and tear, because you documented when you gave the person the unit, there were no holes in the wall. There was no stains on your hardwood floors, right? How many of you have beautiful hardwood floors that you spent $5,000, $10,000 getting resurfaced, and then 3 years later when a tenant exits, there are stains because they had plants and they poured water on their plants and they had nothing to prevent the water from pooling onto the hardwood floors and all of a sudden staining the hardwood floors, and it costs you another couple $1,000s to fix it. Tenant claims, hey, that's a small little puddle. Why is it costing you $2,000 to fix? They say because hardwood floor refinishers send their kids to private school. They're expensive, right? And the goal is we always want to make sure that move-in process is correct. And I will say this, if I talk to 10 real estate owners, I would say maybe 3 of them understand security deposit rules properly. So we have the move-in process. We now have the new law about 1 or 2 months security deposit, but we also have the pre-move out right of inspection. So most people think they do the accounting when the tenant gives the keys and you're all done. They forgot that a tenant has the right to a pre-move out inspection where you're to inspect the unit before they move out, give them notification of what deductions you intend to take, and give them the right to fix those deductions or fix those repairs before they leave. And most owners are not familiar with the complexity of the law, and they get to small claims court, and the small claims court judge asks them, did you give them a pre-move out inspection? You took those deductions, but you didn't give them the pre-move out inspection. You say, what's a pre-move out inspection? And then you lose your case, even though you have a puddle on your hardwood floor. So it's very tricky. The most important thing is that you do this thing correctly, and your property manager should be familiar with the security deposit rules. Habitability. The biggest issue in handling a non-payment of rent issue is a tenant asserting that there's a habitability violation of the property. There are core things that you must provide: heat, functioning water, stairways that work, garbage receptacles, that if you don't, you're violating habitability rules and a tenant can rightfully withhold rent. And if you go forward with a non-payment or rent eviction, one defense to an eviction action is that the place is not habitable. Your job and any property manager's job is to make sure that if someone makes a request for a repair, you respond, right? You don't let an email drift because you're going on vacation to Europe, because you're going to the Olympics, and you're going to deal with their problem when you come back. No, you address it. Response, reasonable time responding. If the request is unreasonable, you simply say, I inspected your unit and I don't find your belief that there's a problem credible because I brought my person there who inspected and there's no problem, right? And as long as you document it, you're fine. Remember 24 hours notice. You're supposed to give written notice. I like doing that. We're working with licensed contractors. We're providing proper notice, and we're inspecting the unit once or twice a year to ensure that we're providing a habitable dwelling. And there are some tenants who are so focused on their day-to-day life, they don't notice a water intrusion issue. You inspect the premises, you see the ceiling's got a stain. What's going on? And they say, oh, I saw it, it happened over the winter and I forgot about it because I got busy with my job. You need to be inside the unit because it's your building, you invested in it, and you can't expect a tenant to be the eyes and ears of the building. There are some tenants who their hobby is their tenancy, and they will make you miserable. But there are some other tenants who are so disinterested in what's going around them that your building is deteriorating without them telling you, and you don't know it because you believe no news is good news. No news is good news sometimes, but at least it must come with twice a year inspections, and that's perfectly acceptable. Doesn't have to be a big inspection, just walk the unit. Oftentimes I find that when a tenant refuses an inspection, that's an indication that there's something going on inside their unit they don't want you to know about. Cluttering and hoarding, subletting, cannabis cultivation, alterations to the premises, like they put in an extra bedroom, or they've got another drywall, they cordon off a space, or they put in their own lighting, or they've got something going on that they didn't get permission to do. So I like the inspection process because I learn more about the tenant than they anticipate. If they don't let me in, I know there's something I have to be suspicious of. If they let me in and the place looks great, I feel proud, I'm happy, and I move on, right? So we always want to do this, and if you don't do these inspections, you create liability for yourself. Fair housing laws. I touched upon fair housing laws, but I want you to recognize sometimes you don't even know you're violating fair housing rule because you don't know the rules, right? So if a family of two parents and three kids apply for a two-bedroom unit, and you say, well, that's too much, I'm gonna be providing water and I'm gonna be providing gas and it's not single metered, that's too much usage for my space, I'm gonna deny them and say, it's too many people. What would that look like? Discrimination based upon family size. You keep your mouth quiet and you don't say things like that, right? You don't talk about people's age. You don't talk about people's disabilities. You don't talk about people's family relationships or how they structure their life. You don't talk to them about, hey, there's a church right next door. This will be a great place for a family that actually would like this church. I'm a member of the church. You don't talk about that. If someone has an emotional support animal, you welcome the application. If someone has Section 8, you welcome the application. Not being familiar with fair housing laws, I've got clients who get a letter from the Department of Fair Housing or the Civil Rights Department, and then they have to hire me, and it costs them $5,000 in attorney's work, and then they have to pay a fine to the fair housing, and then they have to go and take fair housing classes simply because someone asks them if they accept a service animal, and they say, hi, we have a no pets filter, right? Boom. And there's attorneys that are making money simply by checking on people doing that. So you want to make sure that you are aware of fair housing. And if you're not, one choice could be hiring a property manager to locate that tenant and place the tenant. And so you have someone doing your leasing, but not do post management. You can have someone who's hired to handle the leasing that insulates you from the liability if the property management company makes a mistake. But that's another approach you can take. Another thing, with property management and with your own tax responsibilities, you've got to have reports, your profit and loss statement, your year-end statements, your recurring bills. You've got to be able to have documentation to provide to your accountant. And if you're not doing that effectively, you're likely missing out on some of the benefits of owning real estate. Some of the benefits of owning real estate is that your expenses, your interest payments are deductible, your business expenses are deductible. But I have clients who are so disorganized, they're not operating efficiently, and they're ending up creating more cost to themselves and paying taxes when they didn't have to. And I will let you know, property management is a line item deduction on your return. So if you're cash rich on your building, but you can't stand the stress of managing because you'd like to go and see your kids on the East Coast, but you feel tethered to a property, one option is determining whether property management works for you. How many of you have failed to register your units? The rent registries that are popping up throughout the Bay Area, Oakland. If you don't register your unit in Oakland, it's a defense to an eviction action. In San Francisco, if you don't register your unit, you're not entitled to rent increases. When you register your unit in San Francisco, they send you a document called a rent increase license. You now have a license to raise rents. In Berkeley, there are also repercussions for not registering your units. You've got to register your units. Before someone hires my office for a landlord-tenant dispute, one of the questions I ask is, did you register your unit? And my client in Texas says, huh? What? What do you mean register? I pay my registration fee with the rent board. What are you talking about? I say, no, there's a rent registry now. And like, are you kidding me? I'm so glad I got out of California. It's communist, right? Rent registries are a way for the cities to collect information. We don't know what ultimately that's going to do, but we do know if you don't register, there are repercussions. So if you're looking at me tonight and saying, what's a rent registry? Please email me tomorrow and I'll be glad to provide you the link to get your units registered. It gets tricky if you have an unauthorized unit, an in-law unit, and a unit that you have not registered at the rent ordinance. And then we can talk about what to do and what not to do. One of the big issues for me is the path of least resistance. So if I have a tenant who's not paying the rent, and I know that in Alameda County, it will take 90 to 120 days to transition a tenant out of a unit through an eviction action, I may work towards getting a voluntary move out from the premises. So I'm always about, people call me up and say, Mr. Bornstein, how long is this gonna take? I say, I have no control of the biggest variable, which attorney they get and how hard they fight. Why don't we consider offering them a transition where we waive the rent and have them move out? Sometimes it works, sometimes it doesn't. But it's all about what is the fastest and cheapest way to transition people out, taking into account attorney fees, time, and risk. So we're doing buyout agreements all the time. And whether I can get a voluntary move out or not depends upon a number of factors, but I'm always interested in it because it's usually the cheapest and most efficient way to get tenants out. I often have people call our office and say, Mr. Bornstein, I heard about your no legal fee guarantee, and I also heard about you're going to negotiate deals for tenants to move out. Well, I have a sixplex, and there's a couple of NOVs, there's a couple of notice of violations, there's a rodent infestation. I'm wondering if you would manage the property, would you give me the no legal fee guarantee on these 6 units? And I'm like, wait a second. It's only if we place the tenant in. We don't inherit your problems, right? And if you've got a building that's underperforming, that's not in good condition, that has existing tenant problems, we're not interested. We're not interested because that's a headache that evolved. I can help you solve problems, but I can't take on a dilapidated building because it creates liability for a property management company. I can help you get to a point where we would be happy to manage it, but we first have to sort out some of the tenant problems, whether it's an eviction action, whether it's a buyout agreement. What you have in working with Bay Property Group and myself, of course, in law, is you have that whole triage that can be effective when handling a dispute or when looking at a property that should perform better, but hasn't performed because of a number of factors, some in your control and some not. So if you choose to no longer manage your property, you're considering property management, one of the benefits is you outsource some of the aggravation. And what we are offering is, of course, marketing, move-in, rent collection, inspections, maintenance, lease agreement, 24/7 communication, direct communication, emergency contact, and what you have is the ability to know that matters are being handled successfully in a way that you feel is taking into account your goals. So it's my pleasure to have put you in a position to at least be familiar with some of the new laws, get a window into how I see real estate investments and management, and a understanding of some of the best practices. And I can only hope that in this last hour, you've gotten familiar with some of the ways I see things. And if in fact you have particular questions about a particular issue, I would welcome you to simply email me or ask me the question for the audience that's here, and I'll be more than happy to spend time and put you in a position where you feel comfortable about your real estate. This stuff is tricky, and it's only getting more complex, and it's only getting more difficult and more expensive. So you've got to have thick skin, and you have to be committed to learning in order to be able to be successful in investing in real estate throughout the Bay Area. So I can only say again, thank you for attending. It is a privilege for me to be able to educate you. And I want to thank my team at Bay Property Group, Bharat and Ethan, who are here, who are available to answer questions people may have or talk to you about your investment opportunities or property management. So thank you very much. I know you do. He has one too.